Judgment in the appeal, Woodland and Essex County Council.
Lord Sumption will summarise the effect of the court's decision.
This appeal arises out of a tragic accident at a swimming pool in Basildon, Essex in 2000. Miss Woodland, who was then 10 years old, got into difficulties during a school swimming lesson, became unconscious and was resuscitated, but suffered serious brain damage in the process. The swimming lesson was being conducted in school hours as part of the school's ordinary programme of physical training. However, neither the swimming teacher nor the lifeguard in attendance was an employee of the local education authority. Their services had been provided by an independent firm which the education authority had hired to give swimming lessons to pupils at its schools. Miss Woodland has sued a number of defendants, but this appeal is concerned only with the potential liability of one of them, namely the local authority itself. The full facts are not yet known because the action has not yet been tried. The question before the Supreme Court was a discrete question of law, which the court was invited to decide in advance of the trial. The question is whether, if the swimming teacher or the lifeguard were found to be negligent, the education authority would be liable. The law distinguishes between cases where injury or damage is caused by an employee of the defendant and cases where it is caused by an independent firm whom the defendant has hired under contract to provide services. Employers are automatically liable for the negligence of their employees and certain other persons in a similar position. However, the position is different in the case of independent contractors. A person who hires an independent contractor may be liable if he has negligently chosen that contractor, or if he has negligently supervised him or negligently intervened in his work. In other words, if he was himself at fault. But he is not liable if the negligence was that of the contractor alone. This is because, as a general rule, apart from the special position of negligent employees, legal liability for negligence is fault-based. To this rule, there is an exception which has been recognized for many years, but whose precise scope has never been clearly defined. That exception goes under the misleading name of non-delegable duties of care. In fact, such duties almost invariably are delegable. The real question is whether a person who has delegated the performance of some function is liable not just for his own fault in choosing the delegate, but is absolutely liable to ensure that the delegate does the job properly, although he is not an employee. Such cases are exceptional because a legal liability to answer for the fault of somebody else who is not an employee is a departure from ordinary principles of fault-based liability. Mr. Justice Langstaff decided that an education authority was liable only for its own employees or for its own fault. The Court of Appeal, by a majority, agreed with him. The Supreme Court unanimously allows the appeal for reasons given in a judgment which I have prepared. In summary, the reasons are that in a case like the present one, a local education authority education authority delegates to an independent firm a personal duty of its own to educate the children in its charge and to see to their safety while it is doing so. Such cases have 5 critical features which justify a departure from the usual fault-based principle. First, the claimant is particularly vulnerable and dependent on the protection of the defendant, in this case, a child. School children are perhaps a classic example, but other examples may include patients and prisoners. Secondly, there is already, at the time of the incident giving rise to the claim, an established relationship between the claimant and the defendant, under which the claimant is placed in the actual custody, charge, or care of the defendant, in circumstances from which one can infer that the defendant assumed a positive duty to take reasonable steps to protect the claimant from harm. Thirdly, the claimant has no control over the way that the defendant performs that duty, for example, over who it gets to perform it. Fourth, the defendant has delegated the performance of that duty or some integral part of it to a third party, which then exercises the defendant's custody, charge, or care of the claimant and performs the defendant's functions in relation to the claimant. Fifth, the third party has been negligent in the performance of the very function assumed by the defendant but then delegated to him. The Supreme Court accepts that as a matter of policy, it is wrong to impose unreasonable financial burdens on those providing critical public services, but it considers that there is nothing unreasonable about the imposition of an absolute duty to answer for the negligence of an independent contractor in a case where these 5 criteria are satisfied. The reasons are discussed in my judgment. It should be remembered that until recently, activities such as swimming lessons would usually have been conducted by employees of the Education Authority, and for their negligence, the Education Authority would have been automatically liable. Therefore, in a longer historical perspective, this decision does not represent a significant change in the position. The present issue arises out of the relatively recent practice of contracting such services out to independent firms. The 5 criteria which I have identified bring about a limited extension of traditional concepts of liability, which is fully in accord with the law's long-standing policy of protecting particularly vulnerable and dependent persons. In the generality of cases, schools and education authorities will not be liable for the negligent performance of extracurricular activities outside the ordinary functions of a school, for example, holiday trips, and will not be liable for the negligence of persons to whom it has not delegated any custody, charge, or care over the child, such as persons, for example, working at museums or theatres to which children may be taken by a school in school hours. The result is to bring the liability of education authorities in tort into line with those which have always been assumed by fee-paying schools whose liability arises in contract. These swimming lessons were being given to the pupils at Miss Woodland's school in school hours as part of the curriculum by a swimming teacher and a lifeguard who temporarily took over the custody, charge and care of pupils which had been entrusted to the Education Authority. It is therefore right that the school should assume responsibility for any negligence which may be found to have occurred. The case must therefore now go back to the High Court to find the facts and to apply the principles which we have laid down. But it may be hoped that the parties will arrive at a sensible settlement which will spare all of those involved the expense and distress associated with a contested witness action.
Court is now adjourned.